Thank you very much. Thank you. That was wonderful, wonderful. Good to hear from you, too. This is your host, Glenn Fleetwood, with our third episode of Depuy, Pinnacle, HIP litigation in 1 week. But there's some slight developments, so I want to get into it right away in case there's anybody keeping track of this stuff. This is the only podcast on the radio only podcast anywhere, devoted to keeping track of the status of the litigation between 10,000, roughly, plaintiffs who have been injured by the use of the Depuy Pinnacle hip replacement, and on the other side, Depuy, depending on how you pronounce it, and I've heard about 10 different variations, and Johnson & Johnson, who is the parent company of Depuy. And just a quick recap. And remember, if you're getting any information here that you think is useful, if there's anything here that you think you might want to hear more about, if you have any financial interest in this case where you would want to know right away if Depuy or Depuy decides to completely back out, which is the rumor that is going around, saying that they just may now back out of their representation to the judge that they were going to settle the case. If you're interested in further developments or you just want to hear more of my voice, which I wouldn't blame you, hit the like button down below. And if you hit the subscribe button, you will be notified each time that I have a new episode. And there's a little bell down there you can also click on. That'll let you get a notice that there is a new episode. And although supposedly we're supposed to be one episode a week every Monday, there have been developments this week. So here's where we are at. What has happened? Well, it looks like the case is not moving in the way we had thought. I was told that there would be a reaction by the judge to the motion by the attorneys to have the case put back on trial. To review, in January, the attorneys for the hip company, Depuy, Johnson & Johnson, asked the judge that the trial that they were in at the time, which was actually a retrial of one of the huge verdicts that the 5-person plaintiff panel had won in 2017, the attorneys for Johnson & Johnson Depuy said, why don't you just hold off on this and we'll just settle these cases. We are such good people, and didn't claim that it had anything to do with the fact that they had taken 3 huge punches to the nose. So they made that representation to the court. The court, of course, looked to the plaintiff's lawyers and said, well, what do you think? The plaintiff's lawyer said, well, we're just as eager as anybody else to get our hands on some of that money. So, all right, Judge, let's give them some time to show us that they're serious. Well, they were given the time to prove that they were serious, and it has not panned out. But what really has to be done, and I'm going to try and have this done for Monday's show, I want to find out what exactly, if anything, have they offered. In other words, I know that there are many people, including moi, who haven't been offered anything. So is anybody out there in the position where Depuy has offered them money and they are thinking about it? That's really what I want to find out. Now, Depuy claims that they did settle 3,000 cases earlier in the year. There's different stories going around as to how they determined that those 3,000 they were going to settle. You have to admit it is very strange that it means that when they look at a case and decide to settle it, they're going to settle it, which means that they have almost unlimited amounts of money because they don't know what the people on the other end are going to insist on in the way of a settlement offer to take. But they pointed out 3,000 cases, and boom, supposedly all 3,000 of those settled. I'm not saying that as a fact, but that is the story that's going around. Now, I have heard from my law firm that is representing me, that I am probably not ever going to give you their name because I don't think they're doing a tremendous job. And I have been told that the first 3,000 that were settled, if you're not in that group, that is actually a good sign. The reason being that what they did was they settled the 3,000 smallest cases. In other words, Johnson & Johnson looked at the 3,000 cases from, let's say, a single one-person law firm in Los Angeles was representing somebody, and they said, this guy's not going to come out to Texas. He's not really going to go to trial, and this is where the cases right now are, although there is talk that they may actually be shipped out. The judge has made that a threat, that if the defense in Johnson & Johnson just stalls in bad faith, that he will just deal out the cards 10 at a time to different courthouses, federal courthouses throughout the U.S. And that way, if you were a single lawyer in Los Angeles, you might just get your case sent back here to the federal courthouse in Los Angeles, right across from the criminal courts building downtown, and great, go to trial there, no problem. But what happened was that at this point, or at least early in 2019, nobody had been sent out to another courthouse. And that is still the case. So the Johnson & Johnson and Depuy called the lawyers for those cases where they said, let's see, who is not going to be feasible? Who is it not going to be possible for them to come out here and actually fight us? And, of course, the things that you would look at in that kind of a situation would be, how many cases have they got? If a small law firm of maybe 5 attorneys has got, let's say a couple hundred cases, well, then it'd be worth their while to come out here, rent hotels, rent a house, rent a conference room, set up even an office, and stay here for the pendency of the trial. Because in case you haven't been watching this, the trials have been running about 8 to 12 weeks. That's very long for a personal injury type of lawsuit. The point that we're getting to, though, is that if you have that many clients, it's worth your while to come out here. It's not a scary threat that the court would not send the case back to Los Angeles. On the other hand, let's say you are a small potatoes lawyer and you just for some reason took on 1 or 2 of these cases, these hip replacement cases, and now all of a sudden you're in the position of approaching, or at least being a possible next up in line to litigate your case in Texas. Well, they walk in, they offer you a settlement, you look at it long and hard, and you might even be tempted to oversell the case to your client, because you would want to tell your client, this is a pretty good settlement here. I think if we went to trial, we might not do this well. I don't know how anybody could say that, because if all of the prior verdicts have been $100 million per person, what in the world are you going to say to your client? But okay, they try to sell it to their client as a good settlement, and that's basically what's been happening, and it looks like all of those initial cases did settle, from what I've heard. Now, I should say that they're actually in the pleading papers. The pleading papers that the certain small group of lawyers have filed saying, Judge, please put this back on trial. Please put this back on calendar, and so that we can go back to having panels of 5. Judge Depuy is not really serious about settling these cases. They mentioned offers that were being turned down. So if they are correct, they didn't name any. If they're correct, then there actually are some defendants who said, I'm not taking that offer. That's ridiculous. We'd have to look at the offer, look at the special damages, and decide who is right. But it's very hard to imagine an offer that you have to take when your alternative is to say, no, I think I'd rather go for $100 million. It'd have to be a pretty hefty offer. So we don't have a solid answer to, are there cases out there where they've actually turned down the settlement offer. But I've never seen in pleading papers before a group of attorneys saying, Judge, you should put this back on calendar. That's very rare. It just, usually you don't go to the judge and say, take this case off of the calendar unless you know for a fact that your case is going to settle. So I don't know why Johnson & Johnson or the defense counsel agreed to it, but they did, and I've never seen one where they file the papers with the court and the the plaintiffs, the counsels for the injured people, said, Your Honor, these offers have been very low, have been just basically a joke. Please take us off of this waiting list and put us back into trial. As I mentioned in episode 3, I think it was, that one of the very interesting legal issues will have to be if these people have jumped back in, this group of attorneys have jumped back in and said, hey, we're ready. We've looked at these offers and they are bogus. If they're the first ones to do that, does that change their place in line? Do they get to move up to the front of the line now? And if the judge restarts the case that was stopped, are these guys next or almost next in line? Did they gain a better spot in line by being the first ones to turn down the offer of Johnson & Johnson? I don't know that, but that would certainly be a heck of a strategy. And one more reason why I would be absolutely irate with my attorney if that is something that has happened and if that's a possibility under the federal rules as they apply in Texas. Period. I saw a quick note here about why am I didn't actually say I'm unhappy with my attorney. That's not something I've said, and it's not something I haven't said. But I'm a very, very big believer in an attorney being obligated to keep his client notified of what is going on in the case. And I've handled many, many personal injury cases, and I used to have a system whereby we had a thing called the personal touch, and once a month I would notify them of something on their case. And if there was really no development, I would make one up. But once a month I would give each client an update on their case, saying, hey, here's what's going on, here's the latest development, and I can say for an absolute fact that is not going on with my current attorney. In fact, I'm under the impression, and I'd certainly like to go through my files and check because it's just unbelievable to me. I'm under the impression I've received 3 letters from them in 9 years. So that's not very good. Anyway, so let's get back to, that's the latest update. There is no response from the judge. There was thought that the judge was going to announce a hearing date for the motion by these attorneys on we want to get back to trial, and also with that, I would be able to read through the judge's order to see if there's any finding that these attorneys, by asking that their case be put back in the line, have they gained a better place in trial? Are they closer to going to trial than they were without it? No answer yet, but on the other hand, Monday, there'll be another episode of Depuy, Pinnacle, HIP Litigation. If you've enjoyed what you've heard today, please hit the like button down below and please subscribe. And we are not going to hit you up for money. We don't do that. No ask for contributions. We're not going to send you over some Patreon page or anything like that. Oh, we don't need your money. But if you would listen, and if you know anybody who has an interest in this case, if you'd let them know about this podcast. And we look forward to hearing from you and seeing you on Monday.